We are talking about the last will and testament. Talking about death here, folks. It's very sad. Passing away does happen. I swear to you, it happens to just about everybody. People pass away. We shouldn't avoid it. We should plan for it. This is not legal advice. 100% informational purposes only. In fact, if I'm going to give you advice, it's to hire a trust and estate attorney just like myself. That's what you should do. Who am I? I'm Thomas Atkins. I'm a trust and estates attorney. You could hire me. Oh, that's crazy. Oh, man. What a transition. Amazing. It's almost like I planned it. I have a master of accountancy and taxation. I have a master of business and administration. I have too much education. You're absolutely right. But here I am sharing it with you, not giving you legal advice, just giving you some helpful information. I'm just doing my estate plan, folks, right here in front of you. The last will and testament. What are some key bullet points? I know most people know what this is, but for the cheap seats, the last will and testament is a document that instructs an executor, or often sometimes called a personal representative, what to do with your property and with your minor children should something happen to you. If you pass away, what do you want to have happen? Last will and testament. Now, important information. It's in all caps. Must be important. Here's how I want you to remember it. If I have a will, I will go to court. Now, a lot of people think if I have a will, I don't go to probate. And probate is a special division of the courts that handles administration of estates, that handles that first bullet point of transitioning property, debt obligations, minor children. That's what a probate division of a court does. It's all about this area. So if I have a will, I will go to court. Wills are subject to probate. So if I don't have a will and if I pass away without a will, I'm going to court. If I pass away with a will, I'm going to court. I know. People are like, my mind is blown right now. I thought I was not going to go to court if I had a will. Or, I mean, you're not going to go to court because you're dead. But yeah, that personal representative or executor, they're going to go to court to administer your estate. We'll get into in another video how to avoid probate, right? What are some different alternatives to a will? And some of you bright students, right? I see you. You're sitting in the front row. You're saying it's a trust. Trust is one way to avoid a probate, okay? But let's think about wills. Let's talk about wills. Everybody should have a will. I'm doing my own will right now. Let's take a look. Here's my last will and testament. The best way to start off a last will and testament is to declare it as my last will and testament and to revoke any prior last will and testaments I may have done. Even if this is my first one. I think that's a great idea. Just to say, clear the slate, folks. This is me coming in hot and heavy, telling you exactly what I want. Now, why do I have important family information in here as well? It's because I do want to, define some terms, because later on I say, I want things to go to my children. I want them to go to my children. I love them. Well, who are your children, Thomas? Who are they? So it's important to name them up front and name your spouse up front. Who's your wife? Are you married? Are you not? So if you're not married, you're going to say, I am not married. And if you don't have children, you'll say, I have no children. What this also does is helps identify you, right? Because let's just say, God forbid, your name's John Smith. And John Smith, I'm sorry if your name is John Smith. But if your name is John Smith and somebody tries to probate your will, they're like, is this the right John Smith? Well, let me tell you, if you list out who you're married to, or if you're not married, and you list your children, or if you don't have children, right? And you list some birth dates of those individuals, then it is highly likely that we have the right will, and we're talking about the right John Smith. So it does two things. Helps define some terms, because we're going to talk about my wife and we're going to talk about my children below. But it also helps identify who this guy is up here. Do we have the right Thomas Wendell Atkins? Yes, that's my name, Wendell. It's beautiful. It's wonderful. It should be an author of many, many books. Distribution of my property. Disposition of tangible personal property. I like to make things simple in my administration of what I want to have happen to my property. So I'm doing this all in one big lump. However, there may be things that I really want to go to my boy, my lovely boy, my tough boy. Or there may be things that I want to go to my darling daughter. I love her so much. If I want them to have something specifically, that's what this section is about. It's about a tangible personal property memorandum that could be attached to my will or just included with my estate planning documents. And that's what this looks like. At the top of it, I talk about the date of my will. I made a will on this date, and I made a reference to a personal property memorandum. And let's say I want my little hunk man, my boy, to have my wedding ring. I'm going to describe the personal property here, my wedding ring from when I wed his mother. And I want it to go to Nixon, my son, right? So name and relationship, and of course, address. My will says, if that thing that I was just showing you is completely blank, then forget about it. Don't worry about it. Just follow the residuary. So let's talk about residue. What is the residuary? It just means everything else, right? It's a fancy word for everything else. The residue, not the most charming expression, because, when I was younger and I heard about residue, I was like, sounds like I need to get some cleaner, some Clorox for the residue, okay? Not the case here. The residue is nice. It's just everything else. As you can see here, I just want things to go to my wife if she survives me. And then if she does not survive me, I give everything to my children, or my descendants. What does descendants mean again? It says descendants are my children or their children. I give everything to my descendants per stirpes. Now, per stirpes, that's just a bananas word. Never heard of that before. What does per stirpes mean? If my children are still alive, let's say my wife predeceases me sadly, but my children are still alive, Sloan and Nixon are still alive, then my estate is just divided equally between the two of them. However, let's say my daughter does not survive me. Oh, it's a terrible thought. When I'm talking through this with clients, now imagine your daughter's dead. They're like, oh my God. Yeah, it's terrible. Don't think about it, but do think about it when you're doing this, but don't think about it later, right? Only think about it when you're doing your estate plan. If your daughter's not there when you pass away, but she has children, then my boy Nixon and my daughter's children, they split it 50-50. That means one half will definitely go to Nixon. And then my daughter, even if she has 5 children, okay, Nixon is alive, he gets his one half, and my daughter has 5 children. She is not around. Those 5 children split up the other half. That's essentially what per stirpes means. Now let's just imagine a world, again, where my daughter's not around and she didn't have children. Now, per stirpes arrangement means that my boy Nixon, he just gets everything. So just that little word right there, 2 words, gives you many, many alternative dispositions. Last but not least, this is what we call the apocalyptic scenario. I think it's a good strategy for me. I don't know about for you because it's not legal advice, but for me, I think it's always good to have an apocalyptic kind of provision in a last will and testament. This is presuming that my wife is dead, my kids are dead, and their kids are dead. What do I want to do? Use the intestate statute in the state in which I live. And oftentimes what that means is starts with spouse. If you have a spouse that survives you, it usually goes to your spouse. If you have children, then it goes to your children. If you have no spouse and children, it goes to your parents. If you have no parents at the time that you pass away, it goes down to your brothers and sisters. If you don't have brothers and sisters that survives you, it goes down to your nieces and nephews. If no nieces and nephews, it goes up to your grandparents. If no grandparents, it goes to your aunts and uncles. If no aunts and uncles, it goes down to their children. And if there's none of them alive, then that's where the buck stops. And that's as far as an intestate statute, that's what it's called. It's a law that pretty much breaks all of these people down that say, here's your close relatives. And you know what? We're not going to go reaching any further than those people that do not share your grandparents, essentially. So you could put in a provision like that inside, or you could name some specific individuals. So if at the time no person or entity is qualified to receive final distribution of any part of my residuary estate, I give, devise, and bequeath that portion of my residuary estate to, and I could say right here, my mentor, Robert Aldrich. Love that man, right? Or we could even say, I residue 2, and we could go colon, tab it over, 50%. Sorry, Bob, your share just went down. 50% to Robert Aldridge, and 50%, love that man, 50-50, split it up between those two. So that's an alternative for an apocalyptic scenario. Some best close friends don't have a familial relationship to you that you could use. But I like my ultimate apocalyptic scenario. This type of provision here really, really does plan for the apocalypse, essentially. So the remaining provisions, I'm not going to cover it too much. Name a fiduciary, as I've done here. I want to make sure I name who I want my personal representative or my executor to be, right? Guardian of my minor children, David Clifford Munson, longtime friend, known him since 3rd grade, love him all to bits. Anything should happen to me, I want him to be the guardian of my children. So if you have minor children, this is an important one. If you don't have minor children, then you don't need to worry about talking about guardian of your minor children. Same thing with conservator of your children's estates. For me, I feel it's important to make sure that you have a balance between these two, that you have a guardian over the individual and then a conservator over the estate, the person who doles out the cash to the guardian. It's just a nice balancing act, the same person in both of these roles. It's a lot of work. I don't want to push that on somebody. I want them to split it up. So my wonderfully brilliant colleague, Jordan Matthew Ruski, he'll be the conservator. And then my longtime loved and cherished friend, David Clifford Munson, he's going to be the guardian of my children. And then down here is my statement that I'm saying this is my last will and testament. And this is the date that I'm signing it. Testator, that means me. I'm going to have 2 witnesses come in and witness my signature. They're going to watch me sign this document, and they're going to place their names here. They're going to sign here. They're going to print their names there. They're going to put their addresses on these lines, right? We want to make sure which witness that we're talking about, and maybe we need to get a hold of that particular witness, so we want their addresses there. Remember, no blank lines, folks. And then we have our wonderful notary come in and notarize the witnesses' signatures. Okay? And that's it. That is my last will and testament. I know. It's a sad thing to think about. The world without a Thomas. But I tell you what, it's important to plan for it. That's Not Legal Advice, Volume 2, folks. And join me next time when we talk about something else. Bye, guys.